be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's program will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. We'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following the live event. We encourage you to ask questions at any time during the program by typing them into the Q&A field that's just to the right of your PowerPoint window. Your questions will be answered by the presenters after the presentation. Now on to our presentation, and I would like to introduce today's speakers. Rehan Jalil is President and CEO of Security.ai. Rehan, welcome, and can you tell us a little bit about your role over there in the company?
My name is Rehan Jalil. I'm the CEO for Security.ai, which is a Silicon Valley-based company with over 180 people and focused on providing compliance and PrivacyOps for CCPA and other privacy regulations.
Excellent. Welcome. And joining Rehan on the panel today, Michael Morgan is a partner with the Global Privacy and Cybersecurity team at McDermott, Will & Emery. Michael, welcome, and can you tell us a little bit about your practice?
Of course. Thank you, Dave. My practice is focused on global privacy and cybersecurity. I'm part of a team of about 50 lawyers at McDermott, Will & Emery that advise clients on those issues.
Great. And so with that, let's go ahead and get started with the web conference, and I'm going to turn it over to Mike. Mike, it's all yours.
Thank you, Dave. And thanks, everyone, for joining today. I'm going to apologize. My voice is a little hoarse from a cold, but I'll do my best to be clear. Thanks again for joining today. We want to start off with a discussion on the fundamentals and the basics of CCPA. We are really close to its enforceability date of January 1. So I imagine that many of the folks on this call are deeply involved in CCPA compliance projects. But the basics of this law are that it's broadly applicable to businesses, regardless of location, that collect personal information about California residents. And that means that this law requires compliance efforts from organizations, including those both within California and outside of California. And that extraterritoriality component is something that will be familiar to privacy practitioners because it's similar to GDPR, which included significant changes related to the application of that law outside to organizations outside of Europe that process European personal data. What is a little different from GDPR in this context is that GDPR was an evolution of prior law, especially the 1995 Data Protection Directive. So many of the organizations that were subject to GDPR had previously had in place pretty robust privacy practices in compliance with the Data Protection Directive. CCPA is pretty novel in its approach to privacy issues, and one of the distinguishing features of it is that organizations that are complying with it don't have a sort of strong existing practices that can be built upon to achieve compliance with CCPA. So the effective date of the statute, as I mentioned, is January 1. We've had some amendments recently passed. We also had some recent proposed final regs that were issued that we're going to talk about a little bit later. At a big picture level, what you have with this statute are substantial new rights to California residents, rights that, with respect to sort of consumer data in general, did not previously exist under U.S. law. And it has significant operational impacts for covered business. And that's really an area where I think Rehan's got to be able to make some really helpful comments for folks about how to go about addressing the operational challenges. Most organizations are not staffed with privacy professionals that are in a position to have the capacity to handle all of these areas. But the operational impacts of CCPA are significant and important to consider. Then one of the other defining characteristics of CCPA is the breadth of the definitions and the scope and the provisions that it contains. Incorporation of, at a high level, it's incorporation of principles from European data protection law that define things much more broadly than what we're used to here in the U.S., where our definitions of personally identifiable information under our data breach notification laws tend to be fairly narrow. So turning next to the rights that are created under CCPA. The ones that receive maybe the most attention have been that consumers have certain rights regarding their personal information. Under U.S. law, prior law, and continuing, is that you had the FTC Act that had privacy implications because it prohibited unfair, deceptive acts and practices, which could implicate unfair privacy practices or deceptive privacy practices. You also had existing laws related to mandatory disclosures of certain practices. I'm thinking of Cal-OPA and other laws that required things like privacy notices and transparency in certain regards. And then you have the creation of new rights with respect to consumer information, rights of disclosure, portability, and opt-out. These are rights that did exist under U.S. law in certain contexts, like the Fair Credit Reporting Act and HIPAA and certain highly regulated silos. But this is the first time that these rights are being embraced in the context of sort of general, ordinary consumer information. There's also a prohibition on discrimination against consumers who exercise their rights. Another important sort of pillar of this statute is requirements related to security. Businesses are required to implement reasonable data security. And I would suggest to everybody on this call to really think about what this statute means with respect to information security. The CCPA does something that no other statute has done before, which is recognized as a private right of action coupled with a statutory damages provision allowing an award of up to $750 per record for the compromise of consumer information. That is a really big deal, and it probably is not receiving as much attention as it should. That amount creates a strong incentive to file cases in data breaches involving California records. And it's going to create a situation where when you're calculating the losses or the potential exposure, for those of you who are lawyers for your clients of data breaches, it's very likely that the California, if you're talking about a data breach with data spread sort of evenly across the country, the exposure for California is going to vastly outweigh the exposure in all the other states combined. And it requires compliance efforts and legal risk mitigation efforts in the realm of cybersecurity. For breaches, it's going to be really important to limit notifications to California consumers, and that means really strong forensics in data breaches to try to limit the California notification class. In advance of incidents on the planning side, it's going to be really important to think about the availability of log data that you're going to need for that analysis, and updating incident response plans to contemplate robust incident response and limitations of notifications to those individuals who don't have a right to it. In the past, you were able to, in large breaches, in many instances, it may not be worth doing the additional forensics because the consequences of sending of a somewhat over notification were not quantifiable, and oftentimes large breaches didn't result in lawsuits. But that's going to change under CCPA in all likelihood. And then, of course, improving cybersecurity. If you look at the, we have some sort of informal statements that were made by Kamala Harris when she was AG about the use of the Center for Internet Security Top 20 controls. Your information security groups need to be sensitive to the fact that the work that they're doing, identifying vulnerabilities, could give rise to create evidence showing unreasonable security. Information security groups exist for the purpose of implementing good information security practices, which include vulnerability identification and then vulnerability remediation. There needs to be some real thought about how you're identifying and documenting vulnerabilities and the decisions that are made about whether and how to address them. That's a really important issue, and as part of CCPA compliance projects, it deserves attention. The penalties, I mentioned the private right of action, but also you have California AG enforcement available under the statute. Let's go next to applicability. And this is where every CCPA compliance project begins, thinking through whether or not your client or your company is going to actually be subject to this law. Some companies get out because, in the first phrase in this definition, they're not a business because they're not organized or operated for profit or financial benefit. We've seen some cases where it's not entirely obvious whether or not the entity is nonprofit. It's kind of entities that look sort of nonprofit-like, but may or may not. So that's an area where companies, if they are nonprofit or they think they're nonprofit, they should think about that exemption. And then a couple of other things to think about. It's basically a three-pronged test. If you've got gross annual revenues in excess of $25 million, that sweeps within basically the vast majority of medium and even sort of smaller businesses that do business in California. It's not, obviously smaller companies may be able to get out because of that. The second prong is if you annually buy, receive, sell, or share for commercial purposes personal information of 50,000 or more consumers, households, or devices. One of the questions here that I have on this is, does that mean, do you have 50,000 California IP addresses in your web access logs? Because that would sweep in a whole bunch of companies. It's not clear to me the way that issue would play out, but this is another prong that could trigger application of CCPA to a business. And then deriving 50% or more of your annual revenues from the sale of personal information. An important feature of this is that you're also a business if you're an entity that controls or is controlled by a business that qualifies under these standards and that shares common branding. So if you have an entity that has sort of affiliated organizations and they all share common branding, the entity that, depending on whether you're looking up, meaning you have a small affiliate that is controlled by a larger entity, these sorts of considerations arise in a good percentage of compliance projects where you have to consider whether or not the CCPA obligations extend to affiliated organizations. And then indirect application for service providers and third parties. So with respect to service providers, that is also a pretty significant work stream in these matters, is making sure that service provider agreements are written in such a way that they comply with the statute so that folks who are service providers can avail themselves of service provider provisions in CCPA. The identification of personal information is a critical part of CCPA compliance projects. With respect to large organizations, we tend to map out the business lines and then identify the personal information that's collected in each of those business lines, not too dissimilar to your Article 30 records of processing under GDPR. Here you'll see the definition of personal information, which is pretty broad. Information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. It was good to get the clarification under AB 874 that it has to be reasonably capable of being associated with the consumer or household. Allows us to have some limitations on just how extreme the scenarios we need to think of regarding re-identification of data that we thought was de-identified. So that's an important clarification. The CCPA does identify certain categories of personal information, and these include things that previously were not covered by within the definition of personally identifiable information under the laws of the data breach notification laws of California and elsewhere. Things like IP addresses and purchasing and consumer habits, browsing history, search history, geolocation, those sorts of things. Those now constitute personal information. And then you have broad definitions of things like collect. We go on. You also have a broad definition of consumer. This is not a statute that, like things like the Consumer Legal Remedies Act, has a definition of consumer that is more narrow. Like in California law, both in the CLRA and elsewhere, we have this definition of consumer as somebody who's acting in the context of a lease or sale of goods or services intended for personal, family, or household use. That is not what applies here. You have a definition that includes natural person. So extremely broad definition of an individual. So it's almost regardless of whether they're acting in a consumer context, it's whether they're acting in a personal context. Also includes household information. Now, let's turn next to the exemptions. These are critical. CCPA includes exemptions for certain data types, including these are the silos of information that were previously have always been highly regulated. So you got HIPAA data, you've got clinical trial information, subject to the common rule, you've got GLBA, and then you've got FCRA. So these silos are carved out because they're highly regulated already. And then you've got an entity exemption for providers of healthcare regulated under the CMIA or a covered entity regulated under HIPAA. These can be challenging because it still remains unclear whether there's an exemption of HIPAA-covered entities with respect to data sets that are entirely unregulated under either CMIA or HIPAA. That's an important issue. And more generally, with respect to exemptions, the challenging questions relate to how to achieve CCPA compliance with respect to unregulated data sets that can't avail themselves of the exemptions. So next is the AB 25, the employee exemption. Short story here is that we're all worried about application of CCPA to employee, applicant, and contractors, and we got this exemption passed, which will sunset in a year unless it's extended, but you still have to, with respect to employees, contractors, and applicants, still need to inform individuals about the categories of information that are collected about them and the purposes for which the information will be used. Really not a heavy lift for most companies to send out that notice to employees, but it is something that needs to be done and really should be done by January 1. And also, HR information is still subject to the private right of action and the statutory damages remedy, so security with respect to HR information is and remains really, really important. The B2B exemption is also an important one to note. There's an exemption now for personal information that's collected during B2B transactions where the consumer is acting in their capacity on behalf of another business entity in the context of due diligence in connection with transactions, because obviously in connection with transactions you're getting a lot of personal information, and the provision of goods and services to the business on whose behalf the individual is acting. It exempts businesses from the notice access and deletion rights doesn't exempt them from things like the anti-discrimination obligation or providing consumers with the right to opt out of data sales to third parties. That was a really important exemption that was passed.